Hello again. Welcome to Reporting from USA YouTube channel. Christie is fighting off calls for him to withdraw from the 2024 White House race and narrow the gap between him and Donald Trump in the Republican primary for president. With less than 2 months until the first votes are cast in the Iowa caucuses, the former governor of New Jersey has failed to gain significant momentum in public polling, despite positioning himself as the most candid critic of ex-President Trump in the Republican primary campaign. While former VP Mike Pence and South Carolina Senator Tim Scott have suspended their campaigns due to a lack of support, Christie plans to continue running and take part in the next Republican debate at the beginning of December in Alabama. Christie claims he must continue running because he is the most obvious alternative to Trump. He is doing well in New Hampshire, one of the early primary states, and his international policy credentials are particularly impressive given the current state of international unrest. However, detractors argue that Christie's continued participation in the Republican race makes it more difficult for the party to unite behind a select group of candidates who can effectively challenge Trump. According to Kevin Chaffee, a Republican strategist at Pentagram Group in Washington, and a former aide to Mitt Romney's 2012 presidential campaign, all of the fundamentals associated with Christie's candidacy are pointing in the wrong direction. According to Chaffee, Nikki Haley's ability to rally support and engage in a direct showdown with Donald Trump will be hindered by his most influential role at the moment, that of a spoiler. Christie is currently in third place behind Florida Governor Ron DeSantis and South Carolina Governor and former U.S. Ambassador to the United Nations Nikki Haley in the 538 COM polling average. Christie advisor Maria Keeler emailed an update to key players last week, saying that more consolidation would only benefit Trump because no one else was ready to challenge him head-on. Attempts to veer away from Trump, the race's clear frontrunner, have failed so far. Leave Trump to the side, run as a Trump clone, ignore Trump, and appeal to as many people as possible, Keeler advised. Neither Haley nor DeSantis has a strong argument to make against Trump. What would they be able to do if the field became even more competitive? The Christie camp has also noted that their candidate, the former governor of New Jersey, is in a tighter financial position than his other Republican opponents, spending $1,800 per day as of October 1st compared to $38,000 for Haley and $123,000 for DeSantis. Christie could benefit from the upheaval as well. In this video, the legal team for former President Donald Trump is making waves in the political world. We'll explain it all, but first we'd appreciate it if you haven't already, you'd take a second to subscribe to my channel and enable bell notifications so you don't miss a beat. According to Raw Story on Friday, November 24, 2023, a request to obtain all documents related to former Director of National Intelligence John Ratcliffe's grand jury testimony is based on evidence that may exist in the case. The significance of this has prompted conjecture. New York Sun editor A.R. Hoffman thinks Ratcliffe's reporting, which is rumored to challenge the 2020 election results, gives the disclosure request significant weight. Hoffman thinks the latest Trump campaign move could. There's hope that Ratcliffe might know something useful to the ex-president. President Trump's requests for documents related to Ratcliffe's grand jury testimony stand out among more general requests for documents in federal election interference cases due to their narrow focus on the former advisor's testimony. Analysts described the overall investigation as extensive and stressed the potential importance of focusing on Ratcliffe's testimony. Hoffman contends there are hints in the public record about the topic special counsel Jack Smith was pursuing, despite the fact that the content of Ratcliffe's grand jury testimony remains secret. Given his high profile in the Trump administration and his opinion on the upcoming 2020 election, the former Director of National Intelligence's words could prove to be pivotal. In the middle of allegations of election interference is former Director of National Intelligence under the Trump administration, Christopher Ratcliffe. Trump's attorneys have filed discovery requests, suggesting they are trying to find evidence to back up allegations of election fraud. Ratcliffe's testimony has been called key evidence that could help decipher the complexities of election interference cases, and this has been emphasized by political analysis. There has been much conjecture about the specifics of what Ratcliffe would have told the grand jury, and there is hope that they will be made public in the near future. As the legal battle continues to unfold, the nation remains on edge, awaiting insight into the inner workings of the Trump administration's approach to the 2020 election. Concerns about the impact of the former spy master's revelations on the unfolding story are amplified by the discovery request targeting Mr. Ratcliffe's testimony. Whether or not Mr. Ratcliffe's statements prove to be decisive is something only time can tell. In this video, we explain the political ramifications of the former Trump administration's request for information. But before we go any further, if you're new to my channel, please take a moment to click the subscribe button below and enable the notification bell so you don't miss a thing. Evidence may exist in the case, as reported by Raw Story on November 24, 2023, when a request was made to obtain all documents related to grand jury testimony given by former Director of National Intelligence John Ratcliffe. The legal situation surrounding former President Donald Trump and a case in Colorado has recently been updated. The Supreme Court of Colorado has agreed to hear appeals in a case that raises the question of whether or not Trump should be disqualified from appearing on the state's primary ballot in 2024. Now let's get down to brass tacks. 6 Coloradans filed suit against Trump, claiming he should be removed from office due to the 14th Amendment's Insurrection Clause, which dates back to the time of the Civil War. The lawsuit claims that Trump should not be allowed to run because of his role in the rebellion on January 6th. However, a court in Denver just this month ruled that Trump should be included on the March primary ballot in Colorado. Judge Sarah B. Wallace, while acknowledging that Trump engaged in insurrection within the meaning of Section 3 of the 14th Amendment, which prohibits individuals from holding office if they engage in insurrection after taking an oath to support the Constitution, held that this clause does not apply to the presidency. The Colorado Supreme Court has set oral arguments for December 6th after both parties appealed the Denver District Court's decision. On the specified date at 1 p.m. in the Supreme Court courtroom, both parties will have 1 hour to present their case. Among other things, Trump's legal team disputes Judge Wallace's finding that Trump engaged in insurrection and is asking for that finding to be overturned. Nonetheless, the judge ruled that Trump's name should also appear on the opposing side of the ballot. The plaintiffs are seeking a reversal of the ruling that 14th Amendment, Section 3, does not apply to the presidency. Colorado State Judge rules in favor of Donald Trump, allowing him to remain on the state's ballot despite insurrection charges. Trump gloated over this court victory at a rally, saying the media was losing it because of it. However, Jill Wine-Banks, a seasoned legal expert, offers a contrasting opinion on the implications of Trump's win. Wine-Banks discussed the fairness of making a public servant ineligible for office due to participation in an insurrection on Miss Embassy's American Voices with Alicia Menendez. Since the president serves as both a military and civil leader, the former Watergate prosecutor argued, the president is covered by the 14th Amendment. A number of wine merchants argued that there is no real difference between the presidential oath and the oath taken by a senator. She emphasized that the president has a dual responsibility to uphold and defend the Constitution, with the former being the heavier of the two. Therefore, in her view, the claim that Trump is not an officer is baseless. Wine-Banks concluded by implying that Trump will be disqualified from the presidency because his victory in Colorado was illegitimate. This perspective raises concerns about the former precedent's possible legal consequences, despite this win. Wine-Banks recently gave an interview in which she criticized a judicial ruling as being unconstitutional. The judge had made a factual finding that Trump is an insurrectionist, which, if upheld, could bar him from holding public office. Wine-Banks believes that any higher court will likely find that barring individuals with such a label from the presidency was the intended consequence of the decision. Trump's 14th Amendment case will be heard by the Colorado Supreme Court on December 6th, according to a tweet by Wine-Banks. It is possible, she says, that the court will agree with the trial judge that Trump is guilty of insurrection based on the evidence presented, but will reach a different conclusion based on its interpretation of the law. Trump, the wine merchants had warned, could be destroyed in cross-examination. During the trial, Trump's legal team argued that he was protected from prosecution as president because of his position. Wine-Banks, however, pointed out that the only way Trump's actions could be justified under this argument would be if they were directly related to his duties as a presidential candidate. His actions are viewed in a unique light. A question of fact remains as to whether Trump was attempting to undermine the election or protect election integrity, according to the former Watergate prosecutor. Wine-Banks doubted the veracity of the claim to protect election integrity and warned that Trump would be destroyed under cross-examination if he testified to that effect. To what extent the judge's ruling will affect Trump's political aspirations is an open question in this ongoing legal drama. A recent filing in the civil fraud trial involving Donald Trump has revealed the full scope of the threats made against Judge Arthur N. Garant. The judge and his staff, especially his chief law clerk Allison Greenfield, have reason to be concerned about their safety in light of the hundreds of threats they have received. Voicemails containing threatening messages, such as, "Trust me when I say this, I will come for you," are among the threats. Indifferent. That's what I am. Another voicemail stated, "Ain't nobody going to stop me either. Resign right this moment, you snake of filth and betrayal. We will find you and every other dishonest, liar, cheat, and thief in the United States. You're just a bunch of communists, that's all you are. We plan to permanently get rid of you." Captain Charles Holland, a court officer, claims that Allison Greenfield has been doxxed multiple times, resulting in daily harassment, derogatory comments, and anti-Semitic tropes, according to the affidavit. As a result, Greenfield's personal cell phone averages between 20 and 30 calls and 3,050 messages per day. The threats have prompted concerns about the safety of the court staff, and efforts are being made to address the security situation. A gag order had previously been imposed on Donald Trump by the court. He had violated it twice, incurring a $15,000 fine each time. An appeals court, however, put a temporary hold on the order, citing Trump's legal and constitutional protections. To emphasize the broad discretion courts have in controlling the conduct of litigants and attorneys in ongoing proceedings, the court officer argues that the First Amendment does not prohibit courts from limiting speech that threatens the safety of the court staff. This incident exemplifies the difficulties and threats to safety that accompany high-profile court cases. Do you agree that Judge Engoron and his team deserve protection from these threats? Please feel free to leave your thoughts in the section provided below. The video's over. Don't be shy about hitting that like button and becoming a subscriber. Our other videos are available too. We'll see you in the next clip.